Okay, so let's continue. Um, so I will not introduce myself again. I've spoken quite a bit. So again, a little bit of logistics because we also people who weren't here at the very beginning. First, we'll have introductory statements for 5 minutes. Everyone, and then we have a half an hour of a debate within the panel, and then 20 minutes of a debate with the audience. Now, in this panel, what we try to deal with is a question of users and new type of users, creators, and their position in Article 17 maze of rules, and what will be the situation of users, how we try to tackle the issue of over removal, etc., etc. So let me first maybe give a little bit of a quick overview here. So overblocking or over removal is something that is in the title, which refers to a phenomenon that we observe also under the existing system, which is essentially it's a rational choice to remove content when you're not sure whether that's illegal or not. It follows from the incentives of the firms, and we observe it empirically, experimentally. So I don't think that's too much in dispute. Magnitude might be in dispute, but the fact that that happens is probably not in dispute. The question is, under Article 17, that issue will not go away. To the contrary, maybe we will actually see much more of it, which is at the core of a debate that we had around filtering and preventive measures, especially cheap preventive measures that might follow. And I think the issue here can be broken down into two issues. So first is we always had this problem of how do we agree what type of uses are acceptable and which are not. And of course, the core of the problem goes back to the InfoSoc directive and the list of exceptions and limitations being cherry picking and essentially with one exception, all being optional. Now, interestingly enough, if we look at the 17, we suddenly have in Article 17.7, we have a list of exceptions that shall be available. And the question is, what is that? My reading is, and I wonder what also our speakers will think, is that this is a de facto mandatory list of exceptions for situations of Article 17. Now, that is quite an improvement to where we are here today from to the past situation, but there are caveats to that. First is, well, to some extent, Court of Justice was already indicating that he thinks that a priority exception, for instance, might be prescribed by the freedom of expression. So maybe actually wasn't such a choice, although it looks like that under secondary law. And second, this is limited to Article 17 situations. So will member states limit it to Article 17, or should they actually turn this into a much broader policy in the online space? I think that's one of the questions. The other implication of 17.7, I think, is that it might be understood as a contract-proof provision. Namely, those are the core exceptions which you cannot contract away as a platform with the user. Well, that's interesting. If that's the case, that brings another implication. Can platform actually decide in its in the way that it operates that it will exclude parody? If this would be contract-proof exception that is de facto mandatory, do they even have a choice? And I think this is one of the very interesting things because it goes into one of the problems that we had until today, which is, okay, even if parodies are legal, platforms can always say, I just decide not to carry it because that's my decision. But if you make them contract-proof, there's a claim to be made that there is some sort of a must-carry obligation under some circumstances. So I think that's one point to think about. Second point, which we'll discuss at length, is about the internal and external redress mechanism. So we have some provisions on internal and external redress mechanism, but what we can see is that actually when it comes to users' rights, this chapter that we'll have here, there's probably the most room for the member states to experiment and think about what they want to do. Because prescriptions here are very open. models that we could think about are many, and hence I think this is where creativity of the member states will be probably needed. So, when it comes to the external redress mechanism, ADR, which we'll also talk about, I think the interesting question is how to design this. And I might share at a later point some of my research on this, but I think what will be very important is how do we set incentives for different players with respect to ADR. And we have to keep in mind on who makes which decisions. There will be decisions that are taken by platforms that might lead to overblocking, but there are decisions also taken by right holders that might lead to overblocking. By which I mean giving information that is incorrect, which also happens quite a bit. And I think these two different constellations should influence how we look at what kind of incentives we impose or superimpose on the situation. Okay, so without saying more at this point, I would give a floor to our first speaker, who will be Alexandra Kucheravi from KU Leuven, to offer her a 5-minute intervention.
Thank you, Martin, and thank you for having me. So first of all, I should probably start with clarifying that I am not a copyright expert. I look at the whole problem from the perspective mainly of the freedom of expression. So my work here is mainly focused on introducing safeguards for freedom of expression in various notice and action mechanisms, so not only focusing on copyright. But coming from this, I hope I can contribute to this conversation specifically on the redress mechanism. So first of all, I think I would like to say that we all realize that decisions that platforms have to take with regard to content are not necessarily easy. There are situations when there's a penis, okay, fine. But for all the others, especially the exceptions, is it criticism or caricature, parody, this is not obvious. And these decisions are now delegated to private platforms, and they are actually about finding balance between different human rights, so right to freedom of expression and right to property, right? So knowing that these decisions are difficult and that mistakes may happen, it is actually, there should be a mechanism to provide a relief, so to provide remedy for situations when decisions taken initially are wrong. So from that perspective, the provision in Article 17.9 actually provides a safeguards to ensure, or at least help ensuring effective exercise of the right to freedom of expression, but also operationalize the right to effective remedy. So I think that it's, well, definitely positive development that Article 17.9 is there, talking about a redress mechanism. But of course, the next question is how to implement it in practice. The provision provides some information or some guidance on that, but not that much. So complaints mechanism, so first of all it talks about appeal mechanism by the platforms, but also judicial redress. So, and then if there is a complaint mechanism, decisions have to be taken with undue delay. Without undue delay, there should be a human review, and also there should be no processing of personal data. And so that, of course, leads us to a number of questions, more and more questions. I think that when decisions like this are taken, they should comply with certain rules on procedural fairness. We have some indications from the Court of Justice, Court of Human Rights on Article 13 or Article 47. We also have indications from last year's recommendations of the Council of Europe on intermediary liability and freedom of expression, that redress mechanisms should be accessible, affordable, right-compatible, equitable, and transparent. Of course, how would that look in practice? I think it just leads to, I have so many questions here. So for example, if there is a, let me get to that, effective procedure. So for example, what would be a result of a of such a mechanism. That procedure should probably specify that. There are a number of solutions, let's say, that could be resulting from an appeal procedure: reinstating content, apology, rectification, compensation. Most of people, when they complain about content being removed, they just want to have it reinstated. But I think that procedure here should be provided, and I would argue that it should be done at the level of the Commission, actually, to improve harmonization. Whether that would be under Article 710 and the stakeholder consultations, that's something to discuss further. But there's also a number of appeal mechanisms that exist already in notice and takedown mechanisms in different countries, notice and action mechanisms, and I think we should definitely look there in how these procedures work in practice, what works, what doesn't work. So for example, if we look at the counter notification procedure in the US, which is actually great in theory, but not particularly useful in practice. Why is that? So, for example, the penalty of perjury for people who want to file a counter notification effectively discourages them from using this. I have many more questions and comments, but I see my time is up now, so I'll leave it for later. Thank you.
Thank you, Alexandra. Okay, next one, Thomas Margoni from University of Glasgow.
Thank you. Yeah, it's probably because I have to leave. Because I'm afraid that I might say something you don't agree with, so I make sure to leave before you have the opportunity to point it out. So thank you very much. It's very nice to be here. It's great to speak towards the end because a lot of things have already been clarified, even to myself. So I'll try to answer to some of the questions that Martin asked us to reflect upon. I think that my main issue here, it's, we could say, economic or incentive-based. So one of the problems of overblocking that I identified is that it's a lot cheaper for platform to overblock than to underblock. That's quite obvious. We all know why. I probably skip on that so I can stay hopefully within the 5 minutes. But you know, if you underblock, you may expose yourself to a liability for copyright infringement. It can be direct, it can be indirect. We've seen this morning. But if you overblock, what kind of action has a user against the platform? Always to keep in mind that the key relationship here is between users and platform. As a user, do I have an action for violation of freedom of expression, something that I have in any case contractually agreed with the platform that it will be reinstated, so the content would be reinstated at its own discretion? It's certainly not as a strong remedy as an action for copyright infringement. So I think that under this point of view, Article 17.9, as just pointed out, acknowledges a very important problem in this balance between positions. Unfortunately, I think that what Article 17.9 misses is that it's not only a matter of having the right structure available, it's also a matter of allocating the right cost across the three parties involved. And here the weak party, if you will, it's users. Users hardly litigate. There is quite abundant data showing that users seldom take advantage of redress mechanisms that sometime the legal system make available. So the problem of the cost of overblocking is not just a problem that relates to the existence of the cost, but is a problem, perhaps most importantly, a problem connected with the allocation of the related cost. And from my point of view, this cost should be internalized by the same actor that has been given the power or the obligation to block, which is to say platforms. Now, I don't think that it was a good idea to give this power to platforms, right? I don't think that, but that ship has sailed. Platforms decide what to block, so platforms should also bear the cost of overblocking, because right now the cost of underblocking, the cost of underblocking, it's borne by users, and that's not an ideal solution because it goes to the detriment of users and to the detriment of freedom of expression. And this is the only way, in my opinion, that we can make sense of Article 17 within the European legal order, within the fundamental rights that European Union law mandates, and also within the very same Article 17, because we have to remember that it explicitly says that quotation, criticism, review, caricature, parody, and pastiche, so exceptions based on freedom of expression, have to be protected, 17.7, and that they should be made mandatory in order to ensure that users receive uniform protection across the Union. This is recital 17. So it's impossible to reach this situation if we state, yes, some redress mechanism has to be put in place, but we don't allocate the cost of bringing this redress mechanism on the party that have to do this. How to do that? Well, there are many ways. I think we should impose a cost on platforms, but we should also enable platforms to do that. So, for example, for the filtering part, obviously, the meaning of the relevant and necessary information in 17.4b is particularly important to identify protected material and best efforts. So if a right holder makes available all the material that is needed to calculate what a filter may infer that is infringing, then the best effort level could be considered to be placed on a higher level. If platform only receives, say, less information, metadata, then perhaps that best effort should be placed at a lower level. Equally important, and that's my last point, however, is not that platform be put in the situation to identify lawful, so infringing uses, but also to identify lawful uses or users' rights, parody, criticisms, review, etc. So platforms have to be able to train their algorithms on what is parody, on what is criticism. Unfortunately, Article 3 of the Digital Single Market Directive, the exception on text and data mining, excludes platforms from doing this, right? Article 4 says you could, unless the right holder reserves this right. So once again, within best effort, we could also consider whether right holders reserve or not the right of text and data mining. These are just a few ideas. I know my time is over, but I think that my main point here is that there are many opportunities on the table that member states can decide to implement, but the ultimate goal is to recreate this balance. Because if there is no balance, Article 17, if there are no teeth in 17.9, I don't think that Article 17 is compliant with the EU legal order as it stands. Sorry for going a few minutes over. Just one.
Thank you, Thomas. Well, a link with the TMD exception and best efforts. Well, I haven't, in my best efforts, not anticipated that. But it's quite an intriguing thought. So next speaker would be Christina from IFPI.
Yes, thank you very much. So I represent IFPI. I am IFPI European Regional Council here based in Brussels, and naturally followed the discussions regarding the directive from its inception till the end. So coming to the point of exceptions, so in a broader context, freedom of speech, protection of other fundamental rights, my reading of the directive would be that it actually provides a lot of legal certainty and safeguards to users. And it does so for two main reasons, which are enshrined in two key pillars, which we do not see in legislation today. One is, which already was mentioned by some of my colleagues, is the obligation on member states, a very clear one, to make certain existing exceptions mandatory. The thing is, when we look at 17.7 and we see how these exceptions are framed, they are not actually the exceptions per se, but the allowed uses. Because if we look at InfoSoc Directive, Article 5.3 D and K, which refer to specifically criticism and review, and then parody, caricature, and pastiche, we see a slightly different framing. But because we see the reference to certain existing exceptions, and we know that in Europe, under the continental legal tradition, the exceptions, which is different from fair use, are regulated under the list of certain exceptions, we would naturally rely and would be suggested to follow the wording of InfoSoc directive, which would be also a logical and quite systematic reading of both legal instruments in my view. And as rightly said, recital 70 makes it very clear that those exceptions have to be made mandatory across EU member states. Second point, complaint and redress mechanism. It's a very important tool that has been given to users under this directive. First of all, because it is statutory. While at the moment we see, of course, different, let's say, means, technologies, and schemes operating in place, these schemes are, as a matter of practice, linked with the current state of redress and complaint mechanisms in certain specific cases. Here, however, we have a statutory obligation on platforms to put effective and expeditious complaint and redress mechanisms in place, which is, in our view, quite a big step in the context of Article 17. Now, important thing to mention, again, looking at the text of the directive, that what regards the actions to be taken by platforms, there is nothing in the text to suggest that platform should a priori decide what would be lawful or unlawful. And that is why we have, logically, the redress and complaint mechanism. Otherwise, it would make no big legal sense. So, on the contrary, if the platform had to decide at the moment of the uploading what is legal, what falls, and what is against the current exceptions in place, I would think that the whole point of Article 17 would be rendered ineffective and inefficient because it's not the purpose of it. And last but not least, I think some of the things that I hear a little bit on the panel start on a quite misguided, let's say, misguided premise or bad footing, let's say, overblocking in itself or something that has not existed today. I think it's needless to say that there are a lot of sophisticated places or technologies, in place, which already provide the schemes under which redress and complaint mechanism functions. And of course, right holders are in a position to assess whether certain uses, certain content would fall under certain exceptions or limitations. Again, similar to what already exists today, the statutory redress and complaint mechanism would only enhance those systems because I think the parameters of how it should be transposed are quite clear in the text and would guide member states what to do. The rest I would leave for the discussion, but I think this is the statements I wanted to make. Thank you.
Thank you very much, Christina. Okay, next one will be Paul Keller from Kenny's Land and Comunia.
Yeah, I'm actually not with Kenneth Land anymore. Anyway, sorry. So I'm with Comunia, and I think I'm supposed to disagree with the previous speaker, but I think I almost fully agree with most of what she said. But let me go first back to one question, which to have something which might be controversial in here. First of all, you asked if should these parody and quotation exceptions become mandatory or should be considered mandatory. From our perspective, of course, there's nothing in the current situation which prevents the member states from making all of the InfoSoc directives mandatory and finally do what the Commission has failed to do, namely harmonize users' rights in the European legal space around copyright, right? But I agree, it's probably more than just making them mandatory what's happening in 17.7, I would argue. But we clearly think users' rights need to be harmonized. We have harmonization, large amounts of harmonizations of exclusive rights. So with regards to the question of overfiltering, there will be large amounts of overfiltering. Thomas has laid out why that will be the case. There's also already huge amounts of overfiltering, right? Like the content recognition mechanisms on the big platforms overfilter permanently. We all know that anecdotally there is projects which document this. And there's basically three different sets of sets of reasons for that. Two have been mentioned here first. So shoddy rights information, people claiming rights that they simply do not have is one big reason. The other one is incapable filtering algorithms who simply cannot understand users under exceptions and limitations. And the third one is malice. Like, we see a lot of abuses by these systems ongoing that try to, especially aimed at creators who publish on these content platforms, to try to take away revenue from creators and put that into the pockets of existing rights holders. In the music industry, that is a big problem, where owners of music basically demonetize material that's on YouTube and claim the revenue streams with that for tiny uses of like guitar riffs and things that are used in uploaded filters. So there is economic incentives to abuse these systems to overfilter. Now, I agree that with regards to this situation, the directive in 79 is a big step forward, right? I would go further, and somebody talked about putting teeth into the system, right? Like, I would go one step further and say, like, 17.7 is not only an obligation on member states to make these things mandatory, it's an obligation on member states to make sure that users and creators can rely on this exception. What does relying on these exceptions mean? Not contracting away to some content filtering algorithm the ability to just get something taken down or get demonetized or anything. So if member states take this seriously, they need to come up with mechanisms that prevent these types of activities from happening, right? And there's one way that we could imagine making this working, and that is to some degree turn the burden of proof around for certain users. So we want people to be able to rely on these exceptions. What we don't want is people to simply upload everything and just say, like, we cannot filter this because we might violate users' rights. But you could come up with kind of de minimis rules which say, like, if there is certain de minimis uses of protected works on a platform, so it stays, for example, under 5% of a video work, or it stays under a certain length of the use for an audio work. In that case, a takedown request or a blocking request does not result in the immediate takedown or demonetization or blocking of that material, but would result in the communication of that claim to the user, so the user can first contest this. And now it becomes interesting with 79, because 79 says at the stage where a user contests a takedown request, there needs to be human review. That passes a lot of the costs of this system towards the platforms, but that gives probably users a much more meaningful way of playing this out and contesting their rights. And in the end, like, it probably also, because human review and the redress mechanism also creates costs for malicious rights holders who make these claims, also changes their bargaining position. So if you have a strong system like that, you have something where member states can ensure that users can rely on these exceptions. So it's not about only putting these exceptions on the books, but coming up with mechanisms that actually give meaningful power to users to claim these rights that they have under these exceptions. So much for now. Thanks.
Thank you, Paul. This is very interesting. It very much aligns with my view of this being more of a positive obligation to assure the outcome than just put something on the books. And I think that indeed seems to be the strong statement in there. Okay, our last speaker will be Federico from Buke.
Yeah,
Federico?
thanks a lot. So thank you to the Martins again. It's a real pleasure to be here. But, and I fully agree with you when you say that the exemptions are mandatory. It was already mentioned here, Recital 17 makes it rather clear. But there's still a shortcoming in the fact that it is not broad enough. As you know, as you might know, we were asking for one of Bilk's main demands during the whole procedure was a UGC content exception. And that was not delivered at the end of the day. But this is what we have. We have paragraph 7, quotation, criticism, review, caricature, parody, and pastiche. It is something that it is valuable and can be very helpful for the consumers, but just again to say it's not as broad as we would like to. Having said this, it's really important to realize that the main challenge will be how to balance the obligation on the platforms with the respect, on one hand, to make the best efforts to obtain authorization, then basically all the obligations provided in paragraph 4, and then on the other hand, the obligation to respect the user's right. I mean, the key to a user-friendly system is really on how to find this right balance. We believe that in order to tackle the issue of overblocking, it's important to do that beforehand. We already talked in the previous panels on how we can do it. Licensing is, without any doubt, one of the best ways of doing it. And it becomes even more important because of Article 17, paragraph 2. We're talking about a provision that basically covers the acts of the users if they are not acting on a commercial basis. So the question here is, I've heard someone mentioning, I'm not an expert on licensing, there are many more experts in this room than me, but I heard someone saying it's 80%. Are we really talking about 80%? I think it would be useful to know some figures. But of course, licensing would be the ideal scenario, but we know that beforehand this will not happen. Another example, Paul already mentioned, is creating a de minimis rule. That indeed is a very interesting solution or proposal for a solution. Meaning if a consumer is trying to upload the content, and if it's the level of similarity to the original content flagged by the right holders is less than a certain threshold, 10, 15, something that it is to discuss, it should stay online. Another interesting solution regarding the redress, now jumping into the redress and complaint mechanism. So before I was just how we can avoid overblocking, and now how we can deal with the redress and complaint mechanisms and make them consumer friendly. Because at the end of the day, as it was mentioned already as well, consumers don't complain. And that's the reality. And we have to take that into account. We need to make sure that whatever practical solution we come with, it reverses the trend. And I think, indeed, reversing the burden of proof is the right approach, and really try to ensure that consumers are aware that their content might be legitimate in certain occasions. I'm going to try to make it in practical terms in the case of a redress and complaint mechanisms. So imagine if you try to upload a content which is blocked, and you receive a notification via email or a pop-up, and it has to be explained to the consumers in that pop-up, in that email, that under certain conditions, their content is allowed to be uploaded. And if the consumer, while reading that, decides that his content falls under one of these exceptions, and it clicks on that, then the content stays online while the platform is reviewing the complaint. So this is, for us, really one of the key points for our member organizations, so national consumer organizations, is really to ensure that the consumers, when they complain, the burden of proof is reversed, and by default, the content somehow stays online. Because if not, it will lead to a situation where there will be massive overblocking. So I'll stay for here. We can talk about the ADR system. I'm sure we will have time for that. Thank you.
Okay, thank you very much. This gives us a lot. I will start with something that Thomas said, only for logistical reasons, namely that Thomas has to leave in a few minutes. So I'd like to pick on what Thomas said about the fact that one of the ways how to approach this is to create incentives on the platforms, on their side, to take the overblocking as a phenomenon into account by, I infer from what you're saying, some sort of fines on platforms. And here are my few questions, and of course I invite also others to reflect on that idea. I have myself proposed something different, something very similar, and also tested it in the lab experiment, but that is under notice and takedown, so it's slightly different here. So here are a few questions. What do you do about situations which platforms cannot influence? That's the reference to the quality of data. Because they might be making wrong decisions for the data they have received, which is outside of their reach, and that's one of the issues too. Second, will imposing fines mitigate the fact that they already bear now strict liability? So can you cancel out this very strong incentive that they have is to comply, because otherwise they risk strict liability now? And third, how would this work? How would you measure whether they have failed? I assume you mean systematically failed, not in individual case. so that you want to impose some sort of penalty. So how would you operationalize this? I'm trying to push you now on that idea. So please share your thoughts.
That's your punishment for me leaving early, right?
Yes.
I mean, these are all valid questions, and I'm not sure I have specific answers to that. I think that my starting point is, the identification. So my starting point is from the user's perspective, and what I feel is that despite 17.7, the rest of the structure of 17, it's highly a dialogue between right holders and platforms. And in this dialogue, users have been slightly, largely, in part, we can discuss how much, how big this part is, neglected. So from this point of view, the default cost, so if the cost falls somewhere, the cost for overblocking is on users. I really like the idea of 17.7. I think it's very important. But at the same time, we cannot forget what already emerged. I mean, we can have, again, a different evaluation of the quantum, but users tend not to litigate, there is a strong tendency to, it has been blocked. Sure, I don't do anything. It could, I don't know, maybe I annoy the right holder. The right holder starts some sort of other, legal proceedings against me. I don't know. I'm not sure. We as lawyers specializing in this area are not entirely sure. Imagine the position of a 17 or 22 or how old you want it to be, amateur producer of content. We are largely talking about non-professional creators. So my problem here is how to protect them, how to remove this cost that right now, in my opinion, largely is borne by them. 17.7 is in this direction, but I still think that it only partially does the job. An inversion of proof, sure. These are all elements that can be factored in a proper analysis of how to move away this cost from users to platforms and to a proportionate amount. I think the right word here is proportionate. Also right holders in case, I think that platforms should not, so I don't think it is a good idea in the first place to ask a private company, especially, or well, it's more than one, but it's a handful of private companies, to determine what is freedom of expression in Europe. Because, privatized enforcement doesn't really bring us too far from this. Right now, we're asking to a few big companies to tell us whether this use is parody or not. Imagine when these companies are not US-based. I'm just already not uncomfortable with the fact that they are not European. But, at least the US has a strong freedom of expression, First Amendment tradition. Imagine when they will come from somewhere else. So I don't think that was a good idea to start with. But as I say, that's the current situation.
Okay.
So from an economic point of view, the only way to balance this is to create a counterbalancing cost on the platform. How exactly to do it? It's a matter of degrees. So, and I conclude, the better data the platform has, the better their estimation, the better their training algorithm can be. If the data that the platform receives is not of good quality, say only metadata and not full text, then probably within the best effort we can set their liability to a lower stage. This could somehow balance how much of the cost they have to carry and how much of this cost has to be split, if you want, between the platform and the right holder. My real problem is not too much about the platform and the right holders. I think that they have the tools to defend themselves. My main concern is how to protect users, because I think that in all this, in the internet ecosystem are the party that have been left without enough protection here.
Okay, so just to clarify, when I said data, I meant reference information. So
Yes.
this is my piece of content. I'm the right holder, and there is abuse happening there too.
Yes.
Either by claiming what no one owns or by claiming what someone else owns. Okay, so can I invite also others to reflect on this idea? Yes.
I think it's very important to put the discussion in the context. And the context we understand should be very factual, because we hear a lot of things that there will be a lot of overblocking, there will be a lot of misuse, and there is already a lot of overblocking in place. If I look at our data, and I think this is the data that for the music industry I can rely on, is that in 2017, IFPI received only 2,346 counter notices after 4.5 million notices notifying with URLs platforms. So which amounts to 0.05% counter
Okay.
notices.
Can I say something on that? That
That's
information
because they
that
don't have
information
the
says
notice.
nothing, because because if people don't use our counter notice because A, don't have it, and B, they're being discouraged from using it, that you cannot use that information to draw any conclusion on
No,
what
but
is the
I
over
think-
removal.
I think because there was no any other data provided, we hear a lot of information about overblocking removal. So I would rely on something that, let's say, we operate in, and we see counter notices bringing the arguments first. Licensing, that users thought that the content had been licensed. So it's one argument that circles around regarding the counter notices. Another argument is a fair use argument. Indeed, that certain content was removed because it fell under the exceptions and it had not to be removed. I think for us, contextually, this is a very important data, because we first of all learn how many counter notices we receive following our notification, and how many counter notices we receive and on which basis, so that we can assess, let's say, how to move forward. Second thing, let's say, what I already mentioned, we are not operating in a vacuum. There is a lot of process and technology dealing with these issues already. Why so? Because, as we already know, the content had been monetized already for years, and there were means and technologies in place to do so, which also partially included the redress and complaint mechanisms, although they were voluntary, right? So this is where we see as a step forward vis-a-vis users, because there will be something mandatory. And in that process, naturally, to assess whether certain content falls under the exceptions or limitations, human review is involved, because technology is dumb. Technology cannot assess which content.
But human review by whom? So we're talking content ID here. So human review by
Human
whom?
review, so as a first step, of course, the ones who receive the counter notices and would assess that, right? So be that right holders.
Okay.
Now we have a parameter given by this law that there will be duly justification required by right holders. So again, we see the enhanced level, that right holder would not be able to say, yeah, I just think because, you know, it falls under certain conditions, so we have to remove it. So there is some sort of obligation that would be for the benefit of the users. And the human review is also ingrained in the text of the directive, at least I see it, that before any re-upload or, again, disablement, let's say, is put again back to place, happens, there will be a human review put in place by the platform within the mechanism that would have to assess whether certain content falls on the exception limitation. Very important, that does not preclude users to ask for judicial remedies in those cases. And
Okay.
this is again
I think
clearly stated.
I think we need to
I
also
just-
give other people a chance to react. So
I
ju-
just want to put a little bit the data in place because
Yeah,
for
but
me
the
it's
data
very
we have to also put
hypothetical
the data in
out
the
of it.
scientific context too. So the data that you mentioned is not representative of the over removal because we have qualitative studies showing the removal rate is much higher, and the inference that you make is doesn't hold. And an existing system under Content ID, there's no human review but by the right holder. So there's no human review by the platform. In the new system, we hope for that. Whether that will happen, we have to see. But I think we have to also put that into the context. So other people, would they like to react to what was said? Okay.
Thank you. So we mentioned already several times that the exceptions are mandatory, but it's really important to clarify that as long as we don't make them really in practice for the users mandatory and something that they can benefit from, they are just useless and will be kept in this piece of paper without any efficient use. So it's really important that whatever mechanism we come with, it has to make consumers use them in practice. And just another element that also is extremely important, whenever there's a complaint, and let's assume that there is a complaint, the timing. And that was one of the main critics before the directive was being adopted, and I think it's still relevant. Now that we're discussing the implementation is, whenever there's a complaint, the internet is about the moment. I mean, it's about something that you upload, and if you upload it tomorrow or in a couple of days, it might no longer be relevant. So that's something as well that it's not an exception, but should be taken in consideration, which is the timing on in which the review process will happen. So yeah.
Excellent, because this is exactly on a point that I wanted to pick. So what seemed to be emerging here is that, so there's agreement, it seems, on the fact that there's a mandatory exception. Some of us might even think that this is even going beyond some sort of obligation to assure that that's the outcome. But the interesting thing is, of course, there are situations and situations. So in some situations, we might be comfortable with the idea of an ex post redress review, namely after something is taken down and we are arguing in the shadows. And in some situations, we would like that to be happening while the content is up. Now, my question is how to distinguish that. So one idea was that a user pre-flags, essentially, in some way, what they consider to be, I don't know, covered by exception or important or something else. But, you know, that also is prone to misuse. We saw misuse of counter notices too in the United States. So does that mean that what kind of conditions or what kind of process should we think about to distinguish these two situations? I think many people would probably agree that there are situations where we want something to be, as a current event, up because it's important. On the other hand, in many cases, we would also agree that it's completely fine that the debate is happening in the shadows while the content is down. How to make the determination, how to design the process. Should it be tied to authentication of the user that is pre-flagging something? Should they pay something before they pre-flag something? What safeguards do we put on this to prevent the abuse? Because abuse will take place. That's obvious. What do panelists think? Paul, you seem to be like.
I think I made the point like where I would like I'm not sure where that pre-flagging idea is coming from. Maybe from an earlier panel, but I think and I do not agree like that people will not contest. Like I think the current system, and as a result of that, your data is probably also flawed. Is just stacked against counter notices, right? Like there's no incentive to give these counter notices. It's a daunting process. There's uncertain outcomes. There's very little to win with. I think the moment where I am, like we put users in control and let them assert positively that they have the right to do something while that is still up, where they can basically play the ball in the other field and continue doing what they were doing, what they believe was right. Like we create a different set of incentives, and we probably see more of these assertions of rights that could come together with these systems giving education about somebody has flagged your content. Here's a number of reasons why that might still be allowed. There might be systems that help you in making an argument for very common kinds of uses under exceptions and limitations that would change these things. But I don't think like that most of the uploaders probably do not think in terms of trying to express like come with a legal strategy before making an upload, how to ensure that an upload is there. So this pre-flagging idea strikes me as kind of like overly academic and not connected to the world. So
They can learn.
why should they? Why honestly should we burden users who are making relatively day-to-day uses of rights that they have with the burden of like actually having to put a strategy into place to exercise their rights?
So-
Like, that's not how rights work. Like it's
I can hear you, but the struggle is how do you separate the two? That stays. So if you're saying it's not a user's choice that predetermines that, it has to be platform predetermining that because right holder has no influence over this part. So are you now saying that there should be the platform making that choice for what is important enough to not go down while the dispute is happening?
No. Like I would argue that this should be made at some kind of like policy level. I mean, we have the stakeholder dialogue in 1710 that is in general words tasked with finding ways to achieve this balance. And I don't think it should be a case by case thing. It needs to be on a separate thing, like a 100% upload of a protected work without any changes obviously is not something where this should benefit. On the other hand, like one of the, I mean, in the times where I was speaking, like had functions where I would try to educate people about copyright, there is these kind of like intuitive, making sense notions about certain minimum times of that you can use a sample, a quotation from something. And maybe that's just like common sense that lives with people and that we can bring on the level of these guidelines for doing this. So why not say like any use of music, and I'm just like throwing up a number, under 30 seconds in a track is in first instance will be treated as probably justified, whereas anything else that is longer than 30 seconds is treated as not justified in the first instance. I think that will, I mean, that's never going to be perfect, but that is at least a sort of high-level starting point for making these determinations. And I mean, these will be data-driven systems. Like we can maybe ensure that like the usage data of thus brings us to better determinations over time.
So I give Thomas, and I guess one thing you have to think about is then you have to write the same provision for text, for pictures, and for everything else. So think about how you do that. Okay, Thomas, and yeah.
Just one comment regarding the de minimis rule. It's not a novelty. It has been proposed during the legislative process, and the decision was not taken to put it in. I think there was a moment where we saw it in the recital. But I think after lengthy discussions also, given the fact that here we're talking about the exceptions, so we cannot deviate also from the standard rules, and please allow me to say this again, of the general copyright framework. So it's really, again, coming back to your fact, that has been tested during the political discussions and found no place in the text.
Thomas?
And then I leave, so I really say something more. So I think that you know, if I want to leave with a message, my message would be we cannot burden users with the cost of protecting freedom of expression because these will fail. And there is very clear data in this sense. So we can discuss about the specific measures, and I don't have definitive answers on how to rebalance this cost, but the rebalancing of the cost, which has to be split between platforms and right holders, because those are the parties who have the financial, structural, organizational, and motivational power to do this, it has to be carried by platforms and right holders. If it will be carried by users, we fail. We don't only fail from a general public interest point of view, but I think we fail to comply with the strict requirements of Article 17, because it is quite clear that parody, criticism, review, and all the other exceptions based on freedom of expression have to be protected. Now, I cannot imagine that the legislator intended to make such a clear statement without offering any real means of redress. And I leave without allowing any questions.
Okay.
Yeah.
Okay. Thank you, Thomas. Does anyone else want to react to this? If not, I have one more question before we turn to the audience. Namely, so we're talking about ADR. Of course, internal mechanism will be implemented by the platform. But when it comes to ADR, this is where the governments need to get involved. And here's the question: who is that? Is that a European level? Is that the national level? Is this completely self-organized? Should this be sort of industry-led? How do you imagine this to work? And what would be the best forum for this? National, regional, how do you imagine this? Because this is, I think, one of the big questions. And if something could be done in the guidelines, it could be coming up with ideas how ADR could look too. Maybe if we can have a code of conduct, we call for hate speech, we can also have a code of conduct for overblocking. What can we do there?
So ADR, if I'm not a very big believer already in the in the platform supervision of overblocking. I think because of the fact that consumers don't reach that point, so ADR will be the figures will be even smaller. But having said this, there is an ADR system in Europe. There's the European ADR directive. It has been in force for a couple of years, actually. I'm not certain. There are certain principles that can be used. I mean, it requires the expertise, the independence, the impartiality of the body, transparency, effectiveness, fairness. So there are a few principles that we can use. But it also raises a few questions, namely, who pays for it? Again, following on what our colleague was saying, if the burden is on the consumer, it won't fly. That's for sure. So that's something that member states eventually can explore. Should they subsidize these type of ADR platforms? We would definitely support that. Should the traders somehow subsidize these platforms as well? I know we were talking about this earlier, and I know that there's a system according to which the consumer pays a fee initially, and then if he wins the case, the fee is returned to him. So that's also a solution that we can envisage. The question is, and one of the principles of the ADR directive is, it has to be low cost for the user. So that's really something key. But now coming to the main shortcomings of the current ADR system and why is it not very popular with consumers all across the EU. First one, there's no obligation on the traders to join these type of mechanisms. So while the directive makes it mandatory for the member states to put something in place, it doesn't mean that the traders somehow will join these type of mechanisms. And the second point relates to the timing. Again, the EU system doesn't oblige a solution within 90. So they oblige a solution within 90 days. I mean, 90 days for these type of claims it's a lot of time. It's really a lot of time. So I think it's something we can explore. We should definitely look into how the whole system would be financed. But we need to find the incentive, the right incentive, to bring traders to the table. And definitely reduce the period in which the claims will be reviewed, because 19 days is just too much.
Okay. Alexander?
Okay, so Martin, some people here as well, I am a big fan of positive obligations and also under the Charter, the obligation to ensure effective protection of rights. And I think that's where it could definitely come into play to ensure that maybe not ADR, but the appeal mechanisms at least, that there's certain guidance from the legislator. So I would again argue that should come actually from the EU, as this is the initiator of the whole situation, where it actually allows for interference with the freedom of expression of individuals by platforms. Whether this interference is justified or not, that's a different question here, but that's what it is in fact. So to ensure that the rights mentioned in Article 17.7 can be effectively exercised by the users, there should be certain protections, and I think those rules also to harmonize it, so to ensure what's written in Recital 17, that it's mandatory in order to ensure that users receive uniform protection across the Union. So that's what I want to add. Thank you.
Thank you, Alexandra. Now I'm going to turn to the audience, but before I want to say also observation on ADR is that I like in the consumer one. Here, I don't think member states have an option. It seems like this is being prescribed, period. And I think that's a good approach because we saw that even, NetsDG is a good example of an option to have an ADR that platforms could have designated, but guess what? No one is using it. So it doesn't even exist. So to my knowledge, such an ADR body wasn't even created in the hate speech context. So the fact that this is mandatory here makes a lot of sense. And the cost structure will be indeed crucial for the two reasons that you have mentioned. One, accessibility for the users, and I think, and this is coming back to the paper that we have written. This is indeed, I think, a possibility is that users bear a cost only if they complain without success, and on top, connecting to Thomas's idea, our design was actually platforms pays a penalty on top if they made a mistake, which incentivizes them to make less mistakes in the future and helps others. Okay, now with that comment, I'd like to turn to the audience for question. Borg was already waiting for a while.
Thanks very much. I really like this part of the discussion because we agree with everyone on the issue that there needs to be more liability for the users as well. I think this was one of the parts that before we also really asked for this idea for the legislation, we discussed with people, the previous colleagues of Oliveira, from BEUC, or from many other users organizations. And at the time, that what we were hearing is there's already a huge amount of overblocking by the services. So I think this discussion is much better to be titled as not how to avoid overblocking under Article 17, but how to stop overblocking that is already done by the services that are covered by Article 2.6. So, and in that sense, we believe that the legislation is empowering. We know that in the previous environment, the users were not always using their counter notice or any other possibilities. But now, as it is for the right holders themselves that we discussed previously, there will be new people who will be encouraged to become members of societies or try to go after their rights. There needs to be also more consumers who need to go after their rights and then ask for it, because there is now a legislation that provides them with possibilities legally. And I'm also very glad to hear from Oliveira that, as we see, that they see the most important gain for the consumers in terms of the access is making sure that the licenses given to platforms are also covering their acts when they act in a non-commercial basis. So it's actually exactly the point. And where there is an issue, where there's no license exists, and then where there are creators that are doing non-commercial activities and then their works are blocked unjustifiably. There are two situations. One of them is they upload the work and then a notice comes and then the work is removed with an effect of takedown or stay down. And the other thing is when a work is informed, then there's an ex-ante assessment of the work, whether it comes true or not at the first place, which might require different solutions. So I think we agree with most of the people on the principles of addressing this issue. The technicalities needs to be addressed in a careful manner, but I totally agree that things for the notice-based removals, that a better and more efficient procedures for counter notices is a very important thing to challenge the removal of the content that exists, and technological solutions that will be developed through cooperation of the platforms and right holders without putting a burden on the consumer by actually, which is actually already happening, things like saying, for instance, if you tell the technology that 2 seconds or 5 seconds of usages of movies that are used in a certain manner will not be recognized at the first place, then you will address probably 70% of all GIFs and memes already, and then they will go through without being even recognized. You can think of the things that for certain type of usages, that you can even, like for instance, in Germany, it's very popular to have the parodies of the songs. And you can define certain content, as Paul said, that it can go, I mean, not maybe 30 seconds, but you can find the technological parameters to say that certain content goes to a place before it is blocked, that maybe it is assessed or contested. So I think there can be ideas to work on that with the technology at the first place, and you can even make this happen without people are realizing. And I mean, you can save the memes much better than they are actually protected before at the first place by making sure the technology doesn't recognize them at the first place. There was an excellent article of Cenk Ginsburg on that, which was written already, I think, in 2012. And it's also an idea that is being developed in different places. And I think it's an interesting. So that's it.
George was here, and then we moved to
I had to one remark, one question. One is there's this saying, garbage in, garbage out, you know, and when you read paragraph 7, it's quite clear that there's some kind of a joint responsibility of I think the rights holders and platforms to ensure that these exceptions are being respected, you know. And so my question would be there. What do you see as the responsibility of right holders to ensure that the kind of information that goes into the system, what should be recognized, what should be taken down, is of a better quality? You know, there's all sorts of kind of information flowing, you know, between rights holders and platforms. There could be some better development of standards, you know, and quality management systems that help, like to ensure that like the lower quality notices are maybe dealt with in a little bit different manner. Because like if you're gonna try to put everything on the users with the counter notifications and all these kind of things, it's like it seems there could be a lot done by increasing the quality of what goes into the system. The second question is about what is the relevance of other legal frameworks here. We are talking here very like focused discussion on the relationship between users and these platforms, with the copyright regime kind of looming in the background and being implemented here in a particular way and modernized with Article 17. But there are other legal frameworks that are applicable, you know, to this relationship. So what does Article 17 mean for those frameworks, and what can those frameworks mean for Article 17 implementation? So very specifically, consumer contract law. It could be influenced, I imagine, also by what is stated in some elements of Article 17. The 7th paragraph could be very much used to interpret, you know, the relationship from a consumer protection perspective. When you are trying to enjoy a service and you're just not getting the type of service that you should have a right to enjoy. But also data protection rules, of course, are very important. There are a few references in the provision in the DSM directive that this is relevant, but it's not stipulated. So what and I think this is also going to shape the relationship. Yeah.
Okay, so who wants to pick up on the comments or questions that were asked?
I think on the question of garbage in, garbage out, it is difficult to comment, I think, at this stage, because this is mainly the commercial decisions. And, you know, I would, looking at the text, which is for me a very systematic text, in a sense that we come to 17.7 after we went through 17.4. And indeed, by let's say, thinking that now in the environment when the 17.4 would have to take place and the platforms would have to negotiate licensing agreements with right holders, I would assume that a better care is taken also of the content that will need to be agreed or not, and so on. Again, it's difficult to navigate in a very hypothetical commercial situations, but just legally thinking that before we come to the point when, let's say, users would have a stance following also the text, there will be one more step, a huge step, that had to be fulfilled, which is, let's put it, duty of care step. And at the end of that step, and that only the time will show, we might have another discussion by assessing indeed that certain things have changed because there was a better, let's say, licensing agreements in place and the output is much better in terms of quality and so on. And also in terms of, let's see, what is left, what is not left.
But are you saying there's no problem currently with quality of notices going into the...
The question is whether there is no there.
You know,
I have
it's-
to for the
yeah.
audience for the streaming audience. So Joris is asking follow up. Does that mean that you think there is no quality problems with the data that is submitted to these reference databases?
I think generally speaking, and again, I can only speak for the music industry with the data or information I have for the music industry, so I would not rely on any other data. Of course, there are some flaws in the notice and takedown process. And we believe that following the 17.4 structure, there will be an incentive to improve that, let's say, part of 17.4, because it's not entirely anymore only notice and takedown. This is only the third limb of limitation of liability mechanism. And we believe that indeed there will be most probably some need to adjust certain requirements, but for the time being, as far as music industry is concerned, we've been operating on so-called DMCA type of notices because they were built on the concept within the e-commerce framework.
Okay, we should perhaps say that the quality of data is different for majors as is for other smaller publishers. There's a lot of issues there, so perhaps we should also clarify that.
Yeah.
I have Paul and then Federico then.
So to that garbage in, garbage out problem and the quality of the data, there's one fairly general solution to that, and that is increased transparency of the system, right? Like make the required information that's required under 17.4 needs to be submitted into publicly accessible databases that everybody can scrutinize, and where like wrongful claims can be contested, can be corrected, and the quality of the data increases, right? Like that we have less garbage in and less garbage out. That also brings me to one slightly related point that comes up in, like, we also need to be careful. We can come up with all kinds of systems here fixing the problems created by Article 17 in the first place, creating costs for all kinds of players in this thing. But like the reality also is cost can be borne much easier by bigger players than smaller ones. And like creating lots of costs, human review, well-justified things generally incentivizes or benefits the bigger players much more than the smaller ones. And so the more obligations we create here, the more we probably cement the existing system of a couple of dominant platforms, which I don't think is in anybody's interest. And a transparent database in this case for like these notifications where the claims made from rights holders towards platforms are not like individual ones which need to be navigated between potentially endless amount of rights holders on the one side and potentially an endless amount of platforms on the other side, but go via one central or maybe sector-specific, a number of central databases that are open and transparent and accessible to everybody, probably meaningfully reduces also the costs of compliance for especially smaller actors.
Federico?
Yeah, just to reply to Burak. When I was saying that the licensing, I wouldn't consider it the most important element. I mean, it's one of the three layers that I see to ensure the user's right. The first one being the licensing and Article 17, paragraph 2. The second one being the de minimis rule that we can put in place, or the pre-flagging, something that happens through the platform before when the upload is happening. And the third layer is the redress and complaint mechanisms. I think we need to get all these layers right, because that's the only way to ensure that paragraph 7 is respected. But on the other legal frameworks and the question from Joris, I have to admit I only thought about this possibility today when I was reading the last paragraph of paragraph 9, which basically states that the platforms should include in the terms and conditions that the users have right to certain exceptions and limitations. And indeed, I think this relevant, very relevant sentence can create an issue of contractual law. And another question is whether a violation of this right, because I mean, if you're using their services, you're accepting their terms and conditions, and that's the contractual, the acceptance of a contract. And if there's a breach of contract, usually there's somehow a financial compensation. Because as we all know here that exceptions are not seen as rights, but the fact that if they're implemented in terms and conditions, I would argue that it makes them stronger than what they are now. Is that something closer that can go into the direction on something that we can use to claim a financial compensation? I find that very interesting. I don't know if anyone has any ideas on that, but.
Okay, now I forgot my order of the audience. I realize now that it was in the back, and Zhao and Jan. Before I want to say there's one additional benefit of having a centralized database that's transparent, which is that garbage also fights garbage. And that is, if you have a big database where many people try to overclaim, their claims will conflict. And then the right holders have to resolve the conflict on who actually owns that particular piece of content. And this is the case with some of the solutions that are already out there on the market, which have big reference databases and which experience this issue, that right holders come to them, provide reference files, and it turns out that there's a conflict between the different reference files, and then right holders have to figure out who actually owns what. Of course, that doesn't solve the public domain issue and other things. Okay, I think Zhao was probably waiting for the longest, then we go to the back, and then we go to Jan, and I think that we run out of time. Zhao.
I do think we have in the case law of the court sufficient evidence to show that this is in fact closer to a user right than before. So UPC Telecabel, they gave word in some extent to the private copying limitation that tells you that there's an obligation by member states to effectively implement the exception limitation. So if that's true for private copying, much more so here. So that would mean that we have something like a user right. So if that is accepted, then what are the consequences? And this is more of a question as I'm thinking through some of your comments, which is, do I, as a consumer organization, if this is a user right, have a claim for a class action against platforms that overblock and against trusted flaggers that are allowed into the platform system and repeatedly overblock? Would this be some way, an indirect way to shift some of the costs and make actually the exercise of this right possible? Thank you.
Thank you. Thank you for the panel and the very interesting, imaginative solutions and ideas. I think we'll have to be imaginative to implement this directive. I wanted to come in support of the idea of a sort of de minimis or bright lines limit as to what sort of what is the amount of similarity that the filters should flag. And I think, and I wanted to respond also to the counter-argument that you made that indeed in the legislative process, such a de minimis exception has not been accepted. But I think that's the reason why also we should not call it a de minimis exception, because that is not what it is. I think if I read, now I closed my laptop, but of course if you read the text of Article 17, you see Article 17.7, you see that it says that users should be able to rely on exceptions such as parody and quotation. So to me that means also that users should have, that these exceptions should not merely be recognized by law, but should also be made effective. And one way to make these exceptions effective is to recognize such bright lines in order to say, well, let's presume that a 10% similarity is presumed to be a quotation, and as long as we don't have algorithms that are able to spot parodies, let's say that 15% or 20% similarity should be presumed as falling under the exceptions. And so I think that is really the way to defend these exceptions, because else, if we mainly rely on the redress mechanism and such procedural redress, then of course for most users they will be just legal and purely letter protections. I'm Maxime Lambrecht. I'm working at UC Louvain. Yeah.
I have 3 comments. One on your question, whether, if I understood the question correctly, whether it's any infringement of the duty to not overblock is subject to damage claims, and I think yes. Why not? I mean, it's probably up to the national systems. I don't know if that is EU-wide harmonized, but my system in Germany would definitely provide for such a damage claim. Only lost profits, of course, not adequate license fees or so, like the usual copyright damages, but of course, and under certain circumstances, interesting question, Joao, maybe if that is, if we're talking about consumer protection, that would be even subject to German unfair competition rules, and you would have association claims in case you do not comply. Interesting one. You would have to think about that. Interesting one. It's not so far away, I think. It's not so far away that you can claim it. Maybe these kind of systems exist in other EU laws as well. I know it's not harmonized. Unfair competition law enforcement is not harmonized at this level. Yeah, who can claim? But second issue is, I was a bit surprised that I think it was you, Paul, who kind of rejected, I think, the very clever notion Martin brought up, that there should be a certain self-responsibility the uploader should take, and say, I'm sure, you know, for rights compliance. I think it's a good idea, and we know this from other consumer laws, let's say, where the consumer is made to think twice, yeah, and say, I mean, we know this, for example, from giving consent to cold emailing or whatever. The consumer has to think twice and give a second signature, and that's the same system, and I think I like it very much, and I think we will probably see much less wrong filtering if the consumer thinks twice what she or he uploads. So that's why I think it's a good idea. And one last question maybe. This entire system of user complaints is, I think, a subjective right, and it's not possible to contract it away. But what about the guys that are not caught by Article 17? The startups, are they, you know, they are caught, I think, but they only have to do takedowns. So are they within the system? Probably yes. And the Wikipedias of this world and the rest that is not caught, 2.6, what about them? Can they still live without it? I mean, that's something pretty surprising, I would say, if that's the result. But maybe that's the way it is. Maybe you have an answer.
That's a perfect comment, because my last question for the panel to conclude was, now we have to figure out many things when it comes to safeguards, but you know, we probably all agree that there's a positive signal and positive trajectory towards this is developing. But the question is, indeed, this is Article 17 limited territory, and the question is, okay, if we get it right, should we be trying to get it right only in the space of Article 17, or should we now finally seriously roll it out in general, also beyond scenarios of Article 17?
If experience tells us something like that is an extremely big if, that we will get it right? Like if you look at a lot of these questions about this balance, we're honestly discussing them right now because we failed to, or not we necessarily, or we, I don't know who, but there was a general failure to come up with a system that is kind of like understandable, that has clear instructions for national legislators, that has clear instructions for the involved stakeholders. And so, I mean, one can hope that we get it right, but I think the most likely outcome of this is that we create a big mess, specifically because member states will have very different approaches at implementing this, at weighting the different rights at stake, and we'll end up with a disaster of a splintered situation where like all of these like takedown notices will be territorial, counterclaims will be territorial. Nobody has any understanding of what will be going on. So, I wouldn't be that hopeful there.
So this is Paul on horrors of user rights.
Well, I mean, all of the things, like, there seems to be this implicit assumption that, for example, like somebody uploads something on a platform in one member state, and then like there's maybe a claim and a counterclaim, and then it's settled. But the reality will probably be it will be settled for the territory of that member state, because like the next member state will have different rules. That's what's created here. This is why like Article 17 does not belong under a NOMA of a digital single market, because this is a digital fragmented market which is created here, period. And that's not like, unless like somebody stands up and puts some sensibility in there and makes the member states behave themselves and waits for the outcomes of this stakeholder dialogue, which is relatively unlikely to happen, but one can hope, like this will be the outcome and not some kind of like ideal case scenario in any case. So yeah, I'll pass on that question. I just want to go back to that surprise about the thing, like, so my experience in having done user-facing work in copyright, specifically around Creative Commons, where we get asked a lot of things about basic copyright questions, is people simply do not understand copyright. And so I find it very, very, like, difficult to make to make the exercise of rights conditional on something where we either expect them to understand this or kind of like slightly motivate them to make claims that they understand something which they don't understand. So I think there is like, this is such a complex system. It is different in all of the member states. It is just not a reasonable expectation to make someone make a claim that they fully understand that they are doing something in full compliance with the law.
Okay, so we're over time, but everyone should have a chance to give a last statement. So, Alexandra?
Well, I agree with Paul that, well, ideally, yes, but I'm not very optimistic in how that would work in practice, especially if member states start to come up with these rules on their own, and we will end up with the another fragmented mess. Am I also giving other end thoughts? I mean, it's just something that we didn't really discuss, but I find very curious the question about mass carry obligations and whether that will be a result of what we have with the redress mechanism, and how that will play with right to conduct business. So that's something that we're not going to answer anymore. But I think that's a very very interesting question. If you have a right to complain and there would be obligation to bring content back, that's basically what we're talking about here. And then for the data, that quality of data and information that we have about functioning of the complaint mechanism and counter notices, I think also that we could possibly look at some kind of transparency reports here, that we would need to get more information. And NetzDG, it's something that I'm not a big fan of, but in terms of what it provides for transparency reports and what kind of information could be included, it's definitely something that we could look at as an example. So, thank you.
I will certainly be slightly more optimistic, because there are parts in Article 17 which I think we also agreed during the morning session are pretty straightforward, despite, of course, the discussions we might have on some maybe notions. Regarding 17.4, and for me, as I said, a very systematic tale of 17.4, the exceptions or the protection of freedom of speech, that of course the framework is there, the parameters are in the directive, and it remains to be seen how the practice would navigate around them following the transposition.
Thank you. Federico?
So I share a little bit the disbelief. I mean, I'm not sure that this is what we can call a consumer-friendly or user-friendly type of provision. And I don't believe we can, unfortunately, eliminate all the risks. So we can only do the best, and that's where the working group can maybe have an impact, but we can only do the best to minimize the risks for the consumers.
Okay, so we have a mixture of negative or optimistic and less optimistic. I think with this, time is up for this panel. So first of all, I'd like to invite you to join me in thanking the panel. And now, quickly, I would invite Martin to so we can together conclude with a few thoughts on what we have seen and heard today. So, do you want to start, and then I add some thoughts?
Well, I didn't know what to expect today, and I'm not sure I ended up in an optimistic place about the digital single market. It seems to run towards multiple national systems, and one can't be very optimistic about this stakeholder dialogue arriving at guidance which lead to a harmonized system. I think on the optimistic side, probably the European Court of Justice will move in the direction that what they define as active platforms will more or less encompass this new category of online content sharing providers. I think it's quite likely that we end up somewhere in this place, and then the licensing will look after itself, because it's more or less what happened now. And then the weight on the implementation is really on transparency and due process, and there I see opportunities, to arrive at a much better system than we have now. So that's my broad diagnosis. I don't know whether you agree or not.
Okay, so I'll be the positive one. I was very positively surprised by the fact that there was actually more agreement than disagreement, despite the fact that there was also disagreement. But it seems to me that the many aspects, whether that's best efforts or preventive duties, no one is seriously trying to argue that the most horrific scenarios that are, strictly speaking, possible under the language of the law should be taking place. So no one is suggesting you have to license with everyone everything. No one is suggesting that you have same preventive duties, or that you should pay indeed the same amount of money for the licensing deal. So I think that's at least for me positive. I'm also quite happy to see that quite a few points that I thought would be disputed actually seem to be shared, and I think that's great. Of course, there's a big challenge, and I join Martin in let's say cautious optimism, and saying I think that we have created Article 17, by which we have created a lot of responsibility, not only for platforms but for ourselves. So now, member states, European Commission, we need to work properly. And when it comes to user rights, this is 100% clear that there's going to be a lot of mess unless we try to fix it on a European level. At least that's my takeaway. There are ways, but we need to think about this hard. But if we wanted to create responsibility, let's take it up also ourselves. And that's, I think, all I wanted to say. Martin, unless you have something to add.
No, I think we are very interested in hearing feedback on the format of this, round table. It's obviously the policy debates became polarized, and kind of shorthands were used. And if one looks at the detail, the possibilities are quite large still in which way we end. And I think this kind of discussion could help us to arrive at a more rational and a more acceptable system. And we will also see that there's so much flexibility there that certain member states, if they don't want to implement it, they can implement something which looks quite different from what was the headline aim. So I think there's an interest, I think should be at least at European level to facilitate this kind of dialogue. Okay.
So, and with that, please do let us know what you thought of the format, what you were missing, what you thought was great, because based on feedback, we decide whether we want to do more of this. And yeah, that's pretty much it. Thank you very much, everyone, for coming, and hi, bye, everyone who was watching on the stream. Thanks a lot.